Court does call the case of the people versus Marcus Moore Jones.
Andrew Childers, appearing on behalf of the people.
Good afternoon.
You're still here.
I am. Okay. This is the last time the whole summer.
This is it?
Mm-hmm.
Oh, kind of sad. Anyway, go ahead.
Good afternoon, Your Honor. Alex Parks on behalf of Mr. Moore Jones.
Marcus Moore Jones. All right. What are we doing?
Your Honor, we spoke with the prosecution this morning about a potential plea deal. We are asking for an adjournment in this matter to discuss the offer further and to give our client time to collect the restitution.
Okay. So part of the plea is restitution. So timing wise, how much time do you have a number, and then how much time is it going to take him to try to?
We do have a number. A few weeks, Your Honor.
A few weeks. It's your last time. You're going to make this difficult on me, aren't you? How much, young man, you've seen the number that they have?
Yeah.
Okay. How much time is it going to take you to try to come up with that?
Maybe 2 weeks, maybe.
About 2 weeks you're going to be able to? Okay, I don't know what the number is, but that's fine. All right, let me do this.
Not that bad, but it's 700.
It's 700? It's going to take you 2 weeks to come up with that?
I mean, I'll work, but I got priorities. I mean, I know this part of my priorities.
Okay, no. Stop talking, because you're going to get yourself in trouble. No, you saved that one.
No, I'm not doing one payment. I don't want to do that. That's all.
You what now?
Big payment. I don't want to do that. I can't do that.
Can't do what?
700 at once. That's what I was saying.
He'll have it in a couple weeks.
Right. That's all I'm trying to figure out is how long it's going to take you to do that without messing your whole self up. I'm just trying to set a date that you can try to make it happen.
Yeah.
And you're saying a couple weeks that you think you can do that.
I work every day. Yeah, I said.
Well, I know, but I'm just saying you also got bills.
You know,
yeah, I mean, we're just trying to give you enough time so you can do it without.
I said 2 weeks though.
So let's do September 5th is great, Your Honor.
You know what? I'll just make it next week, and then you don't have it, right?
Yeah.
I mean, I'm just trying to give you time, young man.
It is what it is.
Oh no, he ain't gonna say it is what it is to me. He can sit down and you can check him and then have him brought back up.
Thank you, Your Honor.
And you keep shaking your head, and then I'll show you what I'll do. I refuse to be nice or understanding anymore today. Oh, now for something totally different. Court recalls the case, people versus Marcus Moore Jones.
Andrew Childers, appearing on behalf of the people.
Good afternoon, Your Honor. Alex Parks on behalf of Mr. Moore Jones.
Marcus Moore Jones.
We're requesting a 1 month adjournment in this matter.
How much?
1 month.
That'd be enough time for you to get it all together and get. Young man, do you understand what I was trying to do? I was trying to make it easier on you.
I apologize. It was a misunderstanding.
Right. And I just say this. The problem is that you come in, I'm just trying to make it easy on you so you're not stretching it.
Right.
And your attitude almost got you into a whole lot of trouble that wouldn't have even been worth it. Understand me? So just listen to folks. Follow cause conference, September 5th, 2024. 9 a.m. or as your invite indicates, bond will continue. Is he paying? You don't need an order for him to be able to pay that to the court, do you? Or how were you guys going to do that?
I believe Mr. Moore Jones had made a comment that he didn't want to just do it all in one lump sum.
Right.
So if he wishes to make payments, an order can be made so that can happen. I don't have an issue with that. Right? If we submit an order to the court allowing payments to be made on the restitution.
Yes. If you submit an order that we then hold it for payment, we'd hold it as what technically a bond, but to be paid out for restitution. That way, as he gets paid through this period, or as he has the money, he can pay it here so that he doesn't have to come up with it all at once and try to hold it or do whatever.
Okay.
Okay. Okay, you want to do it that way? Okay. So when you come up, the only thing, so you guys have prepared the order, I'll sign off on that. The only thing you have to remember, Mr. Wardell, is when you come up to make a payment, because it's going into effectively our trust fund to hold, it needs to be paid in cash.
Okay.
Okay. Okay. All right. So that way, then when you come up, you can just, you got 200 here, whatever, you can just pay it.
I'm gonna do 3 next month, 300, take half of it.
300 when?
September that day, September 4th.
So
hold it. What are you guys trying to do? Are you trying to pay out the whole 700 or just a bigger or just
I'm at 5th, that was 5th.
On September 5th, my client can pay the $700 in restitution.
Whoa.
Or $675.
Right, whatever the amount is. I'm just trying to make it easier on him so that, because he said he didn't want to come up with it all at once.
Yes, and we were discussing a 2-week. We went back, we talked about it. We think September 5th.
No, and that's fine with me. I'm just saying if, and maybe I misunderstood, was he trying to pay it all at one time? Like he just needed more time, but he was going to pay it all at one time? Or was he going to try to pay it like he'll get his paycheck and then he was like, well, let me do this so I don't spend it.
Right.
Is that what he wanted to do? I just don't know.
See, when we went back, we were speaking on just paying that 700.
Just in one month.
When I came up, he had said the payments. That's why I said I can pay 3 that September 5th. That's what I was meaning to say. But
okay, let's do this. Let's do the order.
Okay.
Okay, and then as he has it, he can come put it, if he has it before then, he can come put it in there so that it's just there.
All right. Can I just come to that office?
Okay. Come to the window up front, make sure that you have something with your case number on it so that they'll give that to you. So that then they'll see it in the file once we get that order in place and then you can just pay on it. All right?
Sounds good.
Thank you.
All right.
Thank you.
Hey. And next time, just check the attitude, man.
All right. Okay?
Because he hasn't done much today, and he almost had to take you. All right? Take care.
Yep. Okay. Go! Will you hand me my screen box? Now go.
Good afternoon, Your Honor. Uwe Dalsapien with and on behalf of Mr. Ahmed, please state your name for the record.
Ahmed Beydoun.
Thank you. We are here for a public cost conference and a motion, I think, from Ms. Reiser. I don't know if we should sit down at the table.
Whatever you'd like. All right. It's your motion. Perhaps could you go ahead?
Thank you, Your Honor. We're asking, we have a motion for reconsideration. The court entered an order on July 18th, 2024 for a release of the video recorded statement subject to the protective conditions. Counsel had objected to the stipulated order that was sent. And I'm asking for a motion for consideration in line with the language in the statute, specifically paragraph 7 in the order that was entered by the courts that the only authorized viewers of the video recorded statement are defendant's attorney, their immediate staff, one defense expert, one defense investigator, and the defendant. And we're asking that, consistent with the statute, MCL 600-2163A, that the defendant, and if represented his or her attorney, has a right to view and hear a video recorded statement before the defendant's preliminary examination. We can provide reasonable access. That's section 11. So we're asking that the immediate staff, the defense expert, and the investigator be removed. So it would just read the defense attorney and the defendant attorneys or attorneys. And then in the event that counsel receives a video recorded statement and requests it to be viewed by an expert, that another order be entered allowing that expert view the video recorded statement. Because paragraph 8 allows for some expert and then the name to be given to the court, but not to the prosecutor. And I think that that is not the spirit or the intent of the privacy that's set forth in the statute.
How does that affect privacy?
The privacy.
If it were disclosed to the prosecutor, how does it change one's analysis of the privacy that you're indicating is contemplated?
The privacy is for the minor victim that's in the recording.
I understand that, but how does it change whether the prosecutor knows or not?
Because it's an order of the court with a specific name of a person. And I'll give you an example. I had the issue litigated before Judge Hunke, where the defense attorney wanted an interpreter to be allowed to go into the jail and review with the client. So the initial stipulated order was entered, but we needed a name of the interpreter who would be allowed to view it with the client and with the defendant pursuant to the statute. And the name couldn't be given. They wanted to take a family member. We don't have any way to sort of enforce it once it is provided, and it can be shown to anyone. And that's not the intent of the legislature.
I don't think the order does that.
The order allows immediate staff, a defense investigator, and a defense expert to review it.
Mr. Goss.
Thank you, Anna. This is a reconsideration motion under 2119F. There is the order that we now have is the result of a motion and a motion hearing that we had on June 27th. There is nothing in Ms. Rice's motion for reconsideration, nothing over what was known, what was presented in the motion. That alone, I think, makes a motion fit to be denied under the court rule that governs reconsideration motions. Beyond that, I have a bigger picture observation. When first came up this video recorded statement and the prosecutor's office we had some issues with the terms of that order. We raised those issues with the prosecutor's office, seeking a discussion and perhaps resolution. At the time, we fully believed that this is something the parties could be sorting out without court involvement. The response from the prosecutor's office was twofold. One, no, there wasn't going to be any changes to this order. And two, if we wanted different terms, we would file a motion. Then we did that, filed a motion, and the outcome of which is the order that we now have. By her reconsideration motion, Ms. Weiser is now basically asking us to go back to square one. It's asking that out of an abundance of caution, the defense should be seeking the court's permission, court's leave, to have an investigator, an expert, and a staff person review the video recorded statement. That we have already done. So as a matter of process, I have some serious issues with this consideration motion. I think it's it.
Your objection is the investigator and immediate staff. In great part. Let's deal with immediate staff. Mr. Dawes, is there a need for your immediate staff to view the video?
There is. We have a staff of a long-time 20-year employee who happens to be a woman. For one, the reasons for having her review the statement is to transcribe it so that I can better evaluate. And two is have her input as a woman in what she sees in that statement. Both defense lawyers for Mr. Bedun are men, and we are prone to missing things coming from that. So those are the
two. I understand, and I think I said on the record at the time, certainly the privacy concerns are paramount, but then there's the ability of the defense to proceed with their case and to be able to properly defend. And I see that the manner in which it's occurring interferes with the defense to the standpoint I don't know that they could properly defend. I mean, if each time before I can make that next move, I have to go to court, and by the way, then disclose who I have necessarily investigating at a point in time to my opposing side of an investigator I may not use. I mean, I guess that's what I'm trying to figure out, and we were going through this before, of how defense counsel even under that scenario functions. And I think that was Mr. Dawes' point during the...
That is correct.
Right.
I believe we have been over this aspect of
or we have. And, you know, and that was really, I mean, when filed as a motion for reconsideration, if there's something that the court didn't take into account, that was it. And I went back and reviewed the hearing, and in light of the motion that's filed, and I don't know that anything that's contained in the motion for reconsideration wasn't touched upon at the hearing itself. I purposely and certainly did not want to be involved in it regarding the court being involved in it. But Ms. Willingby brought up a good point of making sure that to be able to track who has viewed in case there was some something that had occurred. And that's why there was the report to the court. But I've got some serious concerns that the defense, I don't think the statute contemplates that the defense has to show all of its cards and do everything as they're preparing for a case. I don't believe that that's what the statute was intended to do as I go through it. And I don't think the statute really even necessarily touches on that.
That's correct, John. If I may follow up on that, my understanding of the statute and the goal of protecting the privacy of the witness, I don't think the issue there is how many people review that video recorded statement. There's dozens and dozens of people on the prosecution side who have access to it without any limitation. So I think the number of people viewing this cannot be the concern for the privacy of the witness. I think the statute spells out in subsection 11 when there is a protective order for giving that statement to the defense. The statute spells out what are the main items, what are the items of the statement that will play the publication of it. I think that process covers the concern for the witness's privacy, that the statement somehow get lost or be duplicated or get out there or let alone be posted online. All of which the current order prohibits as it stands.
I would agree. I don't think that any of those things as laid out in 11 would be permitted by this.
That's correct.
And I guess it's semantics. It's a different interpretation of the statute. Like you may not release it, display it, or circulate it. You may not show it to other people. Like the defendant, and if represented by his attorney, has a right to view the statement before the defendant's preliminary exam. And I think what distinguishes this from another piece of evidence in terms of this argument that it limits their ability to defend themselves is you can come back and get an order to have a defense expert view it. But it's a piece of evidence that's not subject to disclosure under the Michigan rules governing discovery. It's not released under FOIA.
No, I understand that it's not released under FOIA. I mean, I understand that.
It's not subject to disclosure under the Michigan court rules governing discovery.
Right, may I respond? Ms. Reiser, I think, omits two aspects from the statute, subsection 11. The statement may be provided as otherwise provided by law, and the same subsection then authorizes this court to order a copy of the statement be provided to the defense subject to protective conditions. So I think what the court has done and is looking to do as well in the statute.
I mean, as I understood people's argument at the time of the hearing, and I mean, I guess it's morphed at this point, is that there would be these people seeing it who would potentially disclose that information, which was why I included in the order that the names of anybody doing that would have to be provided to the court. And so that if there were an issue that arose, those names would be provided. So the defense couldn't just, I mean, in the normal case, the defense can take evidence, they can show it to whatever experts they want, decide whether they're going to have this expert or use that expert, not use that expert, do whatever. In this instance, defense has to choose an expert, has to make that expert known to the people, which is really a problem in and of itself. because I may not use that expert. That expert potentially could come to a conclusion in opposite to the position I want to take, and I don't want anybody to know I've even consulted that expert. So, I mean, I think that the court has taken into account everything that was raised as a concern regarding this, placed into its order those safeguards to make sure that it was not disclosed, but at the same time giving the defense the adequate opportunity to do that. I don't see a need based on that, well, for two reasons. One, well, the first reason is that under the motion for reconsideration, these were all issues that were raised and nothing new is being presented to the court. So on a technical basis, the motion for reconsideration would be improper. But even despite that, I think that everything's raised in terms of the protections that are to be granted. I think that the court has done that. Maybe not in the way that defense entirely like me to do it, nor in the way that the prosecutor, but you know, they filed their motion. I ruled. I provided an opportunity for the defense to be able to proceed with their case, the people to know who is viewing it. They cannot disseminate it. The people that are permitted to even see it are covered by the protective order. I mean, I don't know any other way that to do. I don't think that it needs to be as restrictive as the one that was presented. And so the motion for reconsideration is denied for those reasons.
Today's public cost conference on that end, I believe we are looking for another room. There is a dozen more items of discovery still in progress somewhere in the pipeline that we don't have. Last communication from Ms. Willenbrink on that was that they would be provided once they become available.
What is it? We would like to set it. Yeah. What is it you're missing? If you tell me, I'll get it to you before the exam date.
Well, it's literally 12 or 13 items, and it's in an email within your system.
I thought all that was taken care of.
It wasn't.
Pardon?
I suggest that after this hearing, I provide the very same email that has already been circulated.
Well, Ms. Reiser says they'll provide it, but I don't know. What are the 13? You said there are how many things?
13 by Mattel. By category, there's a number of search warrant returns, including like the data, the returns from search warrants. There's pending 2 forensic analysis of mobile phones, Mr. Bedouin's and the complaining witnesses. There must be supplemental reports of the search of Mr. Bedouin's vehicle. Body camera recordings, other recordings of law enforcement officers investigating, speaking with witnesses in the case. And there is a...
What, at which time, though? I mean, some of what you're listing would seem to me to be discovery turned over in a normal course. The only thing I recall Ms. Willenbrink indicating that might be delayed was the forensic analysis of the phones or other electronic devices.
But the items I just listed, they have not been provided. We don't have them. We know them to exist, but we have not provided those items.
Do you see that list, Ms. Reiser, or no?
No, Your Honor, I can't get it.
That's, can you just show Ms. Reiser the list, and maybe she may not know specifically.
I think if we get an exam date in 3 weeks, I can have this information shown. It's the results of search warrants and obviously the CAC interview that will be provided, but search warrant returns are something easy.
Yeah, I mean, those are easy if you know where exactly. That's when was that sent to the prosecutor? Because at the time, I'm not sure what date of the hearing. The only thing that I recall Ms. Willenbrink saying was going to potentially be delayed was the forensic analysis of electronic devices. And that was completely understood. I mean, that because of whatever, but.
I'm perplexed now, Your Honor. I don't recall a discussion of discovery in this case at the last hearing in this case at all.
No, I'm not saying at the last hearing. I'm saying at some point.
Yeah, my email to Prosecutor's Office was of June 14. There was a response on June 14, the one I just cited, that some of them are not available at this point, but we will make them available when we receive them. And when it comes to third one,
well, hold on a moment. Hold on one moment. When was my prior hearing? You said that was on June 14th?
My email to the Prosecutor's Office, yes.
Well, the second search warrant from MSP returned last week that was uploaded into on-base. Counsel should have that. It's a DNA detected. It's defendants. The Apple iCloud search warrant returned was past Friday, and we're in the process of downloading those files for review this week. So that will
Apple. Say that again.
iCloud search warrant.
Got it.
And it's Apple iCloud account. So those are being downloaded right now.
Okay.
The green ones we have, the yellow ones we don't.
What about the mobile phone? The forensic report for the mobile phone?
If we don't have a passcode for that, that could take a year.
Well, see, right. And what I was, and I don't think I'm getting my cases mixed up, but there was talk of the phones, and there was some talk of the forensic things, and there was an issue. I don't recall it necessarily being an issue with the passcodes, although that may have been said, but it was more an issue of the basically a backlog issue. But
I'm sorry, Your Honor. Now that the court is saying these things out loud, I am almost certain it's the other case of ours, Mr. Kranz's.
Okay.
Not this one. We have not had an on-the-record discussion.
So do we know, do you see anything regarding the status of those phones?
Hey, Jones, it's an Apple iPhone.
Say that middle part. That was seized. Okay. So on this list, Mr. Doss, is that the defendant's mobile phone you're talking about? The Apple iPhone?
There's two of them in there. Mr. Bedoun's is one, and the other one is
from
the complaining witness.
Right, but I don't know that you would describe that as seized. But
no, it was turned over by consent.
Pardon?
It was turned over by consent.
Her phone, yes. Right? But Ms. Reiser indicates that there was a phone that was seized. I'm presuming that to be the defendant's phone.
That's the defendant's iPhone.
Got it.
And they did take that's included in the investigation from the victim's phone, the Wiz app. That's how she communicated with the suspect. That's how they met each other. And what they took from her phone, and it's a conversation in the police report, is how she met the defendant, what time picked her up, their conversation. And her last text was, "She's trying to help. I just got raped." So that is in the report. It's not that we would. Looking to see the search warrant. I don't want to get in a situation where we're just adjourning for months on it.
No, I don't either.
To get his phone.
Well, that's what I was trying to. And Mr. Doss may be right. Maybe I'm looking at another case regarding the phones. I thought that was the only holdup, because as I'm looking at these other items on here, and I think you're right, Ms. Reiser, the body cam footage is something that's going to happen upon a request for the immediate request, right? So then I'm looking at there's a police agency, Dearborn Police Department report regarding the arrest. That wasn't contained in.
No, it was not. really the bulk of discovery, what I view the bulk of discovery, has not been provided at this point.
Okay, so
That's not true.
okay, right. I haven't. Let me just say this: I have an issue with you saying that because that's not how any of it in any of the cases proceeds. When the request is made for discovery, what the people have typically they just provide. And then if you are saying that certain things are missing or that you want certain things, and that may be something that might have been referenced in the police report or something along those lines. That I get. What I'm concerned about is that this request for information comes on what date was this sent, Mr. Dawes?
June 14th.
So
We do have a search warrant for his phone, but we have no passcode, so I have no idea.
Is that what they, okay,
done.
Right, okay, so you don't have the passcode. Okay, so if they don't, all right, so and that's for his phone.
For the defendant's
phone. So the way I resolve that is if you want that and you want that report, then have the defendant give the passcode. That makes it very quick because then they can get it. If he doesn't want to provide the passcode, I don't think you can then complain that the people need to provide it because they don't have it. And that's going to take, well, I won't even guess. There are some that still haven't, it seems, shown up. And Mr. Reiser, you were indicating that in terms of the victim's phone, that information has been provided. That
text string. You know, as a general rule, we don't like load the whole. But that the report of that text communication. I'm just looking at the first piece of discovery, and it's 60 pages long. And on page the messages.
Well, while you go through that, you're not asking for everything in her phone, are you?
I am. Her phone in the police report is flagged for forensic analysis, pending analysis by law enforcement.
Yeah, it's right here, digital evidence forensic report.
That's from her phone. Okay.
The list that I created is of items referenced in other items of discovery, mainly the police reports. I go through, I look for what's referenced there, what exists, what is in process.
Right, but I guess what I'm saying is this is on here, and I don't know where. I think what Ms. Reiser's indicating to me, that's been provided, the forensic report on the phone, on the victim's phone.
Yes, these text messages that she was sending while she was in the defendant's car are in a forensic report.
That's not the same as the forensic report of the analysis of the phone. An excerpt of, I'm sorry, Ms. Reiser, an excerpt of some data taken in the police report is not the same as the forensic report of the analysis of the device.
Why do you need everything on her phone?
To see what else is there. I don't know that's what has been excerpted into the report is complete. I don't know what's before. I don't know what comes after.
Well, I'm not going to order that they turn over her entire phone. I mean, at some point, these two met each other through however that happened, right? So what would be relevant to the defense of this case, or even tangentially relevant, of information prior to that point?
Whether she communicated with someone else about the coming encounter with Mr. Beydoun.
About what?
About the coming encounter with Mr. Beydoun. There is communications of the complaining witness with someone else about the encounter, contemporaneous and after. I want to know if there's any communications about it beforehand. I also want to know whether her phone was used in getting around town that day, whether it was used to look up locations where they went.
Right, but that's going to be basically after they've met or communicated with each other, right?
Well, for that aspect, yes. As far as like directions around town, yes.
I don't see what, I see no relevance in what's occurred prior to that point in time.
Well, I don't believe we are in a position to make that finding. Perhaps we should.
Well, I'm not going to order them to turn that part over. I mean, what I think, Ms. Reiser, and correct me, Ms. Reiser, if I'm wrong, is the phone was viewed. They provided what they have of what's on her phone that's relevant to this proceeding.
What they think is relevant, that's not the same as what's relevant.
That's not going to happen. That's not going to happen, Mr. Justin. It's just not. That yes, you're entitled to discovery. You're not entitled for them to do some fishing expedition for you. Not at this stage.
I'm sorry.
Yeah, it's a fishing expedition. I don't. If her phone is however old, let's say 5 years old, you're not going to go back the 4 years previous. At some point, you got to try to give something that connects it up. I mean, I'm not.
Yeah, but the forensic report is listed as an item of investigation in the police report. Therefore, I requested it.
It's right.
We cannot tell.
They sent it to you.
No, they did not. That's an excerpt of something of a much larger collection of data. I don't know if that is everything there is.
All right. Here's the way I'm going to do it, because I agree with Ms. Reiser. I'm not going to keep adjourning this thing out. This list comes after there are a few hearings saying discovery. It seems to me that if Ms. Reiser, if they have that list, they're either going to be able to provide it or not explain why. For example, with the phone, I'm not going to hold up the preliminary examination regarding defendant's phone when they're going to have a hard time trying to crack it to get into it and not allow a defendant to delay the proceedings where the information that would allow them access to give you the report that you're looking for is in the defendant's possession.
I understand that part. But
all right.
Since then, law enforcement has taken out a search warrant for Mr. Bidwin's Apple account. I understand there's a retrial.
Yes,
so that is still
because we couldn't get into his phone, and the investigator is so thorough, we got his Apple iCloud, and that will be ready for pickup either tomorrow or the beginning of next week. It's
which is what you just said.
Yeah.
Earlier.
Correct.
They just got that.
So that is his phone. Her phone is done. I will get the report when he was arrested on the warrant for this from Dearborn PD.
Got it.
And the body cam, and that's all that should be. If they, I don't know to the extent that U of M has what their body cam is, but whatever they have, we will turn over.
My sense of this is that discovery at this point is not complete. It's
okay. Here's what we're going to do, Mr. Doss. All right. I want, because I'm not going to go through and nickel and dime this. It seems to me what the people are getting, they're providing. And I don't think they're making an unjustified, to the extent you're arguing relevance, I don't think they're making an unjustified inquiry or an unjustified saying we're not going to give you something 5 years ago from the defendant's, from the victim's phone or whatever, something before the time that these two people know they exist on the planet. I don't think that the people trying to interfere in any way with the discovery process or what information is provided. So that list, this list here, you can have this back, that is provided. You'll locate that, correct, Ms. Reiser, that list?
Yeah, Ms. Williams.
Okay. Go down that list, get to them what you have, and most of that stuff, at least as I'm hearing you, Ms. Reiser, by the end of next week, that stuff's going to be, you're going to be sending them what you have.
Yes.
Right? Okay. I'm going to give you 2 dates. First date that I'm going to give you is, oh joy, this is going to make my vacation beautiful. I'm going to give you August 13th as a probable cause date. 2024 at, we're doing those in the morning, 9 a.m. Those would be in the morning. That specifically, we're going to hash out, if necessary, what discovery is there. And let me just put it this way. I presume, Mr. Doss, you've had an opportunity to go through the discovery that's there, that the list that was given is the exhaustive list right now of what is missing. That is a list that we're going to work from. And then Ms. Reiser, once she has an opportunity to look at it, provide what information is currently coming in, like the iCloud account, whatever. She'll provide that. We will go through that list of what can or cannot be provided. And then I'll order what needs to be provided if I think it can reasonably be attained. I will then also give you a preliminary exam date, because we're going to do this thing, because we're not going to keep adjourning it out. Preliminary exam date will be August 27th, 9 a.m. That in person, that's before me. And that way, nobody else has to go back through this discovery stuff again.
So that will work, provided Ms. Willenbring does not go on maternity leave. That day will work.
So now I have to adjust my schedule for a baby.
If you put it the first week in September, I will be here and gladly cover the preliminary exam.
I can do the 17th. Okay, what I'm going to do is let me set it the 27th. If that doesn't work, yes, you know I will adjourn around the baby.
Okay.
All right. I do.
May I note something for the record, please?
Pardon?
May I note something for the record?
You may.
I have some serious reservations about the status of discovery in this case so far, including what is and isn't to be provided, and that may be grounds for a motion about discovery. So I think between now and...
Whoa. Mr. Doss, that is what I am trying to do right now. You say you sent them this list. Ms. Reiser says she sent that. I'm going to try to resolve everything regarding discovery on that 17th, on the 13th day. She says she can get what she has on that day. If it looks like there's something that's out there that's not attributable to the defendant or is going to take more time, then yeah, I'll move things as I have to move things. If you want to file your motion, file your motion. But I'm telling you what I'm going to do. I got your list.
The latter part clarified this. Very good, thank you. That we are going to try to sort out on August 13th what it is in discovery and what's left.
That's the purpose of the 13th.
Yes.
That's everything. Bond to continue. You're welcome.
Are you kidding me?
Oh my God.
You have got to be kidding me. What is going on today? This is a joke. Today is an absolute joke. It's an interpreter.
I need an interpreter when I cannot express myself sometimes.
Oh my God, sir, put that cigarette out. I don't give a crap that you are outside of this. What is wrong with everybody today? You know what, Miss Green, we're going to start bringing people in person. You're going to learn how to act in a courtroom.
Can you hear it? Can you hear it? Ma'am? Ma'am? Can you hear it? Okay.
I'm sitting up here, I'm the one that needs a drink.